Hi, I'm Jason Tetlow, the founder of the law firm Tetlow Law PC. Welcome to the Steel City and Conemaugh Valley Law Advocate podcast. I've been helping clients with personal injury and medical malpractice claims since 2001. I created this podcast to provide an overview of the personal injury and medical malpractice processes and answer the questions I most often get when I first meet with prospective clients. My goal is to fight for my clients so they are fairly compensated when they are the victims of negligent actions or malpractice. If you need representation or just have questions, don't hesitate to contact me at 412-248-9600 or visit our firm website at www.tetlowlaw.com. That's TETLOWLAW.com. Any information provided in this podcast should not be taken or relied upon as legal advice. You should always consult with an attorney about the particular facts and issues of your case.
Welcome to the Steel City and Conemaugh Valley Law Advocate, a podcast dedicated to bringing you legal insights on personal injury and medical malpractice law. Brought to you by Tetlow Law PC and featuring the expertise of Jason Tetlow. Let's get this episode started.
Welcome, everyone, to episode 5 of the Steel City and Conemaugh Valley Law Advocate, your trusted legal voice for plaintiffs' personal injury and medical malpractice law in Western Pennsylvania. In episode 5, we're going to continue our discussions on medical malpractice cases and specifically talk about some of the elements that go into handling a medical malpractice case from a nuts and bolts way of what someone can expect that they're going to have to go through in a medical malpractice case. So we have Jason Tetlow here again. Jason, welcome to episode 5.
Pete, good to see you again.
So Jason, we went over in our previous episode 4 about a lot of the elements that make up a medical malpractice claim. We talked about how they're very expert driven, tend to be a lot more complex because you have a lot of elements you have to have into play. They tend to be more expensive to put together because of the requirement of experts and the additional information that has to go into it. And therefore, you have to be more selective in which ones are worth investing the money in, and then also are worth having the client go through all the time and effort that takes it. So today, we're going to be talking about a case that has passed the initial overview from your office of saying, look, we think there's something here. You've now passed it on to the expert to get the certificate of merit, which is required in Pennsylvania to file the lawsuit. And they've confirmed that, yes, we think that there's malpractice here. And now you've brought somebody on board as a client. So what we want to really talk about in today's episode is to give them a good idea of what they can expect is going to happen from this point forward. I think you had mentioned that it's not atypical that lawsuits filed, you're a minimum of 1.5 to 2 years typically from getting something resolved, if at all, and it may go longer if you have to go to trial. So I guess one of the first questions I had for you, and you mentioned there's several stages where a case could get settled. Mediations, arbitrations might get you some resolution there if you don't just resolve it yourself. But do you have a sense for the number of cases you take versus the number that actually end up having to go to trial or all the way through a trial?
Yeah, I think, again, this gets back to the point of the advancement of mediations, arbitrations being a lot more common today than they were years ago. Really, probably a smaller percentage of cases that actually make it all the way to a jury trial. Certainly that happens. And when it does happen, it's more time for the lawyer, more time for the client. Going through a trial is it's not something that everybody does every day. So it's not necessarily a comfortable thing for clients to go through. But generally speaking, it's a really smaller percentage of cases that go to trial. Now, with that being said, medical malpractice cases, you're generally taking it all the way to the steps of the courthouse, even if it does get resolved without a trial. So you're still going through, as the lawyer, as the client, you're still going through the process of the case, which I think we'll get into in a little bit more detail, than just a case getting resolved at an early stage. Generally speaking, these cases, it's going to require all the workup and getting it to the steps of the courthouse if it does get resolved without a jury trial.
And you've mentioned a couple of times now, I think most people understand what a jury trial's about or the concept of it, but you've said mediation, arbitration, and in a prior episode, you talked a little bit about a mediation, but maybe let's dive into that a little bit more so people understand what really is a mediation, its purpose, and what's an arbitration, and how do those two differ?
So the big difference is with a mediation, and nowadays there's a good number of mediators, at least here in Western Pennsylvania. And a lot of these mediators are some retired judges, lawyers that have been practicing for many years that transition into mediation, or there's a couple of mediators that have been doing it for a long time. And they were, I don't want to say pioneers, but they were some of the first lawyers that transitioned into mediation, even when they were maybe a shorter time into their practice. But a mediation is typically getting the parties together, and the mediator does exactly what it says. He tries to come to a common ground and mediate the case between both rooms. Typically, you're going to have the plaintiff and his or her lawyer in a room. In another room, you're going to have the other side, the defense, and the mediator literally is going to go back and forth. And the mediator really just facilitates the negotiations and tries to get both parties to a settlement number that is reasonable for both sides. But with a mediation, it's not binding. Like, you do not go into a mediation and the mediator doesn't say at the end of the day, hey, this is what I think the case should resolve for, X amount, and that's the number. It doesn't work that way. It's not a binding proceeding. With arbitration, usually arbitration is a binding proceeding. And an arbitration is generally more of like a mini trial where you're presenting the case to the arbitrator and the arbitrator is deciding the outcome of the case. So that's the big difference between mediation and arbitration. I mean, typically, on average, mediations are utilized a lot more to try and get cases resolved. However, arbitrations, many times it's a good avenue to try to get the case resolved outside of going through a jury trial. It just depends on the case, depends on the client.
And is it your right or the client's right to determine whether they go to arbitration versus trial?
Absolutely. Yeah. The client, it's always the client's case, right? So the client is always has the final say as to what they want to do. Our job as the lawyer is just to present the options to them, tell them the good and the bad of each, and tell them our opinion. Hey, this is what I think. And, ultimately it's up to the client. Sometimes clients, they want that jury trial. They want their day in court, and that's completely understandable. So sometimes clients realize and, hey, maybe going into an arbitration, maybe that's our best shot of a recovery, based upon the circumstances of the case, or it just all depends. Everything is case specific, client specific. Mediation, what I like about mediation is it's not binding, and you can go into a mediation and it works great. I had one a couple weeks ago and it worked out well for my client. She was very happy with ultimately what happened and ultimately with what was being offered, and she was satisfied, and we got the case settled. Not every mediation results in the case getting resolved. Sometimes it results in progress, and then
Right.
Then it'll resolve down the road. But certainly going into a mediation, you hope that the other side is also going into the mediation with the mindset of let's make a good faith effort to try to get the case resolved.
And I would suppose sometimes you come out of a mediation and say, we're just too far apart. We're going to have to buckle down and prepare for trial.
Absolutely. And certainly that's happened. The sides just aren't agreeing upon, certain aspects of the case, or more importantly, the value of the case. And you can't get it settled. And then you just forge ahead and move toward a trial. But that certainly has happened. And sometimes a mediator can be frustrated by that, right? Because you want to go into a mediation hoping that there's maybe more negotiations, and it doesn't happen. So every case is different. Every case is fact specific, but more and more cases do go to mediation, which I think is generally a good thing.
Do mediations typically happen earlier in the process as compared to an arbitration or a trial, or they could be anywhere where the parties just agree it's time for us to talk?
Yeah, it can really be anywhere. I've had cases where I've had mediations where a lawsuit actually hasn't even been filed. The likely scenario is a lawsuit's been filed, and we'll get into this, I think, in a little more detail. Depositions are taken. There's probably a trial date. You're getting closer to a trial. That's typically, I would say the majority of times that's when a mediation is conducted. But it can be held much sooner in the process, in the middle of the process. There's no right or wrong. It just depends on the case.
And just to give an idea, is a mediation a day, 2 days, a week compared to, potentially an arbitration, a trial? What's the sort of time commitment? And just give the listeners a visual of what this looks like.
A mediation is typically a day, and sometimes it's half a day. My recent experience with a mediation, it lasted, I want to say, 4 hours. It was half a day. And we were able to get the case resolved. And again, case specific, it just depends upon the attorneys, the insurance representative on the other side, the parties involved. A mediation typically never goes more than a day. You know at the end of the day whether the case is going to get resolved or not. So, sometimes it might sometimes the mediator might stay involved and work with the lawyers to try to get the case resolved after a full day. But no, it's not like a week long. Or the nice thing about mediation, it's not as much. I think the right terminology would be is it's not as involved or emotional for the client. It's a lot when you're sitting in a courtroom and you're in front of the jury. That's a lot different than being at a mediation where it's not. Although it's an adversarial process, it's the mediator that's handling everything, right? So the mediator is not there to be adverse to your client's position.
And do you typically see your clients testifying or talking at these mediations, or are they just there? Like how are you presenting information to try to get the case resolved?
There's all different ways. So sometimes I actually will do, and again, this is totally case specific, Pete. I mean, it just depends. It's just like going into a football game. The Steelers might have a different strategy against the Colts than they would with the Bengals and come up with a game plan. I mean, honestly, it's the same here. It just depends on the case. But what I've done in certain circumstances is sometimes I'll do a video of the client, submit it ahead of time to the mediator, to the other side. So they see that. Sometimes it's an interview with the client. So the mediator sees it, the other side sees it. The insurance representatives on the other side see it. Sometimes I've done very detailed like PowerPoints, laying everything out. And that's usually all submitted ahead of time. And there's a reason it's submitted ahead of time, because you want people to review it and understand our position prior to the time of the mediation. So
Gotcha.
The mediator is a little bit at the day of the mediation. It's not necessarily clients testifying. That's usually not the case. Sometimes clients will speak, but the way things have gone with mediations, that's less likely. And usually the legwork is done in advance.
So we have these three major outlets for hopeful resolution of a case. And obviously the parties can agree to settle at any point in time outside of one of these three. But mediation, arbitration, jury trial, I think you gave a good description of the differences between the three. From your experience, for the most part, they're a year and a half, 2 years out from the time that you file a complaint, unless in some instances they agree to mediate earlier, et cetera. But let's back up and say, just like we talked about before, we'll use a hypothetical to make it easy to keep referring to. I think is it Conemaugh Memorial Hospital? That's one of the big ones in the Johnstown area.
It is, yes.
Okay. So let's just say somebody has filed a claim against a doctor and the hospital at Conemaugh Memorial Hospital, where whatever scenario we want to claim, why don't you give us a scenario, a surgery gone bad or something along those lines that we can use to reference what's going to happen along the way for this case, typically in our hypotheticals, we walk our way towards resolution.
Sure. Yeah. I mean, as an example, I had a case against the doctor at Conemaugh, and unfortunately my client sustained pretty significant injuries during a surgery. And, one of the allegations of negligence in that case is that the surgeon used the wrong instrument for what he was doing at the time. And unfortunately, it caused paralysis to my client. So there's a case where we have a case against the doctor and we have a case against Conemaugh. who employed the doctor. And really what happens in the general course of a case is when the lawsuit is filed, the pleading stage, which is, filing certain documents with the court that the client's involved in that they're reviewing the documents, they're signing off on the documents. Sometimes there's a motion that you have to argue early on in the case. But then you get into the discovery phase of the case, and that's the depositions that we've talked about. And what a deposition is you get together with all the lawyers in the case. So for instance, when my client is being deposed, let's say there's one lawyer on the other case. That lawyer is going to ask my client questions, and there's a court reporter there, and it's done under oath. It's just like you're in a courtroom, but you're in a conference room. And so the client gives his or her deposition testimony, a very important part of the case, because again, it's under oath. And, what you're saying in that deposition can be used against you down the road. And more importantly, it's a great time for the client to explain to the other side everything they've gone through as a result of the incident as to which, you're there. On the opposite side of that is when I take depositions, whether in my example, the surgeon in that procedure, then I have an opportunity to ask him questions in that case and ask him why he used this particular instrument and why didn't he use this other one. And so it's an opportunity to ask those questions. That's all part of the depositions are all part of the discovery phase of the case, which is also the discovery phase is really just exchanging written documents, right?
Okay.
So whatever medical records we have, we give to the other side. And most of the times it's just an open book, you're not hiding anything. It's what you have is what you give
Right.
to the other side. And, if my client has loss of earnings, future earnings, I'm providing them with tax records, W-2s, employment file, all that stuff. So that's the discovery phase. And then, working with experts, which we've already retained at that point because we have the experts before the lawsuit is filed. So many times then after depositions, you get the transcript. Experts are reviewing that. Experts are reviewing different things. And, you're maybe getting final reports from the expert or supplemental reports, whatever the case may be. And then, working toward a trial date, whenever that is, based upon where you are, what county you're in. So that's kind of a general overview of, how the malpractice case proceeds.
So it sounds like first stage is probably a lot of legal filings and writings and motions and things like that typically, I would imagine, don't heavily involve the client at that point. Is that correct?
Yeah. I mean, yes and no. I mean, the initial phase of getting the complaint filed, right? That's being drafted by the lawyer, but ultimately the client is reading it and signing off on it, right? So, I mean, we have, clients are going to sign a verification saying, hey, I've read everything. And to the best of my knowledge and belief, everything is true. So clients are looking at that, making sure factually everything is correct, is what they know. So clients are involved to that point, but the more involvement with clients is in the deposition phase, right? So,
which is next, then the discovery phase.
Right. So when you get into the discovery deposition phase, then, meeting with clients to prepare them for the deposition, going through the facts of everything, explaining to them what a deposition is. So that's where there's a lot more client involvement during that discovery phase.
Do you find that in that discovery phase that opposing counsel is often looking for more information on your client at that point? Are they typically going back and asking for historical things or seeing what they're posting on social media sites? Or, what kind of stuff is uncovered in someone's life during that discovery phase? Because I'm assuming, they're going to be looking for anything and everything they can to defend their doctor client or the hospital client in that case.
Generally everything. Social media is the one that's, always a little bit dicey because, some people want to kind of live their life on social media and they post a lot of things. And so, you have to make sure that with certain clients that, what's out there because you're 100% correct. The defense is going to gather up as much as they can in the social media world. And, if you have a client that's claiming a back injury, but they're out skiing and they're water skiing and they're running marathons, well, that's a problem.
Right. Right.
So the defense is going to, they're going to bring all that up, and they're going to, generally they're going to bring it up at the deposition and, ask the client about that. But again, I'm using extreme examples.
Sure.
But certainly it's happened. It's happened in my cases where certain social media is brought up and it's shown to the client, and you just have to be careful. But it's, medical history. That's a big thing, right? So, it's a case where, somebody is claiming that, they have a low back injury or something, from a procedure. I don't know, but they've had a history of chiropractic treatment on their back, history of physical therapy on their back, or they have got prior motor vehicle accidents, all of that. That's all part of the discovery process. All of that is going to be, really ascertained by the defense and then brought up at the time of the deposition.
Do you ever come across where you found out that the defendants have put surveillance on your clients to videotape them to see are they active or inactive as they're claiming?
Yes.
Okay.
Not so much in the medical malpractice cases. I'm not sure. I may have had only a handful of incidents in the medical malpractice world as far as surveillance, but it has happened in other personal injury type cases. Yes.
And that's primarily to see is someone as injured as they're claiming to be, at least by video evidence.
Correct. Yeah. There are certain rules about that video surveillance without getting into too much detail, but there are certain rules about that you don't see that before the deposition. So sometimes lawyers spring that on you at the time of the deposition. I can recall not a medical malpractice case, but another case a few years ago where my client went to Home Depot and he was lifting bags out of his car. But quite frankly, it wasn't really that big of a deal for the injury he had. He could still do those things, but
right.
Anyway,
but they're going to make a big deal out of it.
They're going to make an issue out of it.
Yeah.
Which is understandable. That's their job.
So basically, I would imagine when preparing for a deposition, which sounds like for the most part is probably the most intrusive part to your clients of the whole process. Is that fair to say?
Yeah, I would agree with you. I mean, I think that's because typically a deposition, there's a deep dive into the history, into prior accidents, prior lawsuits, whatever. I mean, and it's not a proceeding that takes a half hour. I mean, again, case specific, it depends, but those are usually hours on end, 2, 3, 4 hours depositions, can last.
And they should be prepared that they're going to come with anything and everything they can find about somebody that they can dig up in the past or have access to, or maybe a videotape or maybe social media, any of those things. They need to be prepared that that's something that could be asked of them during a deposition.
Yeah, absolutely. And it is. I mean, that's been my experience.
So what is an IME?
So an IME is it's called an independent medical exam. So there's certain rules in Pennsylvania, rules of civil procedure, that allow the defense to send the plaintiff to a doctor and have that plaintiff be examined by a doctor. And then the doctor writes a report for the defense. An IME is, it's there so that the defense has an opportunity to hire their own doctor to say, well, let me back up. There's been situations where my clients have gone to an IME and the doctor has said, yes, I think all the injuries and all the treatment that the plaintiff has had is related to the incident. More often than not, the IME doctor is going to write a report that says, well, they may have been injured, but they should have been healed up in 4 weeks, 8 weeks, whatever. And all of these ongoing problems aren't related to the allegations in the complaint, but they're related to pre-existing problems or what have you. So that's generally an IME. You don't see IMEs as much in medical malpractice cases. You see it more so in the personal injury, automobile accident type cases. Although that case I just had that resolved at a mediation a couple of weeks ago, that was a medical malpractice case that my client was sent to an IME, with an orthopedic shoulder specialist.
And they have a right to require your client to do that.
They do. Yeah.
Okay.
Within reason, right? You can't,
Yeah.
If the client's in Pittsburgh, they can't say, go to Philadelphia and see this doctor. I mean, it has to be within a reasonable distance of their home.
Sure.
But they have that right, and that's that happens. That happens not as much in medical malpractice, but more so the personal injury type cases.
And if an IME is to happen, whether it's medical malpractice or personal injury, is that typically before your client's deposed?
Typically it is, yeah. It depends. I mean, my experience is that typically it's before the deposition. Sometimes it does happen after, case specific. But, if I'm on the other side, I probably want to have that IME before the deposition so that you can then ask certain questions maybe that the doctor brings up can be utilized at the time of the deposition.
So it sounds like, again, that we have these motions and the lawyer writing phase. That's the first thing that happens after complaints filed. Ballpark, is that 3 months, 6 months typically, that you again, I know it's going to be different by cases, but that a short or long time frame before you get into this discovery phase, which seems to me from what you're explaining is probably going to be the most intrusive on your client until you get to the point of a trial or some type of a hearing.
Yeah, I mean that initial phase, the pleading phase with the documents, going back and forth and filing them with the court. I mean, that could be anywhere between 3 and 6 months, really. And then, when you get into the discovery phase, then that's usually a longer period of time. I mean, you're looking at 6 months to a year. And then a lot of it then just depends upon, what county are you in as far as when you can then get it on a trial list. So that's where you easily get into that 1.5 to 2 year period, sometimes longer as to when from beginning to end, from the time you file a lawsuit until you get to a trial, that a case, can span that period of time.
But at some point, discovery will close and it's just waiting for trial at that point. You're not subjecting your client to, hey, there's going to be multiple more depositions coming in. I mean, unless something
Correct.
Pops up that's brand new.
Correct. So it's usually once the discovery closes, then there's no more depositions. And then at some point, there's going to be deadlines for exchanging expert reports. Some counties will do that. They'll have a specific deadline just for exchanging expert reports. Some counties, you do that at the time you file your pretrial statement. You attach all your expert reports to it. Again, just depends on the county. Sometimes just depends on the judge, how the judge likes to conduct the time frame and deadlines in the case. So, I had a case recently where I just exchanged all reports within the last couple of weeks on a case, but I'm back in court on it in a couple of weeks. And then we have a status conference then to determine when the trial's going to be. It just depends on the county, depends on the judge.
And so you get through discovery. Now you're waiting for your trial. Maybe this is the sweet spot for mediation to happen. All the facts are out there. Everybody knows basically what you're dealing with. If there's a time to settle it, you're seeing a lot of times that's where those pop up. Or you head to trial. And even if you win a trial, or if you lose a trial, I guess, there's still a possibility of an appeals process, correct? So
yeah, sure.
You can win a trial and the other side can say, well, something was wrong in this trial. I don't think that's the right result.
Yeah, correct. I mean, you still have the right to appeal, and there's certain deadlines that you have to follow within 20 days or 30 days after an award or a verdict for the defense, and there is no award, then there is that time period to file an appeal, and that can just add time, right? So, there's certain post-trial motions that the trial judge would hear. And then from there, then it would go up to the appellate court. Then it's just a matter of when they schedule arguments, so then it could take a lot more time. And then you have cases that can get bounced back from an appellate court for a retrial.
Right. So you're starting that end phase all over again.
Yeah. And I'm not suggesting that that's common. That's in the smaller percentage of cases, and which can just add more time.
Which I would assume is one of the advantages of settling a case somewhere along the way, if you can, is that everybody's agreeing they're not going to appeal. I mean, when you're agreeing to it and you're, signing your name on the settlement document, it's enforceable at that point. There isn't an appeal process other than some really egregious fraud things or stuff like that you're done. You don't have to worry about the thing dragging on beyond your control.
Right. And that's what I tell clients a lot of times too. If they're debating, hey, I'm not sure what to do here, we're in a mediation, maybe there's a number that's my client, wants more, which is, many times is understandable. but the other side's not getting to that number. A lot of times it's, it's the bird in the hand analogy. Sometimes it's better to have a guarantee now than to go through the whole process where there is no guarantee.
Right.
Because I don't know what a jury is going to do in a case. My client doesn't know what a jury is going to do. You could win and do great. You could lose. You just don't know.
Right.
You put your best foot forward and present a good case, but you don't know what a jury is going to do.
Well, and I think it goes back to what was discussed in earlier episodes, which is it's also a chance to move on, put this all behind you and focus on what's next in life. And, this stage is over, and it has to be tied to realities and making sure you're accomplishing the things you need to accomplish. But I think that's a big element for helping people, again, get past what happened to them.
Yeah. I think it's that, like, to your point, it's that closure. Sometimes it's, somebody has a serious injury, someone's lost a loved one, and they've gone through this whole litigation process, and it's, it's tough, and it's time, and it's, emotional. Sometimes getting that closure is the best thing for them to move on and get it behind them.
Yeah, absolutely. Well, Jason, I think that wraps up episode 5. I think you gave a real good overview of what typically happens in a medical malpractice case, what's to be expected after you've agreed to represent a client and you've filed a complaint against them. Is there anything else you can think of to add or advise to our listeners out there as to what to expect in the actual handling of a claim?
I think we've covered everything.
You've done a good job.
Thanks, Pete.
Well, appreciate it. We're episode 6, our last episode for season 1, is going to be talking about referral cases. And this is more driven towards other attorneys that are out there who may not practice in medical malpractice or personal injury cases and get a request from a client or a family member or whoever it might be that are saying, hey, I have this case, but it's not something I specialize in. And I know that's a way that you get a lot of your cases and that you've built up a lot of trust relationships with other lawyers. So we want to talk through that briefly, how that works, why it's beneficial for attorneys to do that, or if a client has an attorney they trust, but it's not their specialty area, why they may want to recommend they talk to you. So we'll get into that in episode 6, and that'll be our wrap up for season 1. So we'll talk to you then.
Thank you for listening to this episode of the Steel City and Conemaugh Valley Law Advocate, brought to you by Tetlow Law PC. If you're in need of legal representation, visit tetlowlaw.com today to connect with our team. We look forward to helping you win your case, and we'll see you on the next episode.